Hey everybody, Robert Chesson here, Landlord Law Firm with your July edition of the Landlord Advocate. Happy summer to all of our Landlord Advocate subscribers. I hope you're having a great time. Today's topic, tenants won't let me into the premises to do my work, do maintenance, do inspections, to show the place, whatever it might be. We get this question often, and so I thought I'd cover it real quickly for you here in our video edition of the Landlord Advocate. The law is pretty straightforward. You have a right to access to the premises to do the work you need to do, and the tenant does not have a right to withhold that access unreasonably. Reasonableness is a term that we create in the law so that there's never a definition for it, but nonetheless, they can't simply continue to tell you no. If they do tell you no, you actually have relief in the statutes here in Connecticut that allow you to go to the court, get a court order, and gain access to the premises. I'll share with you the quick language of that statute. If tenant refuses to allow entry, landlord may obtain declaratory judgment or injunctive relief to compel access or terminate the rental agreement. In either case, the landlord may recover actual damages and reasonable attorney's fees. One of the few places in our statutes that provide specifically for attorney's fees, but nonetheless, what it says is you can get a court order to gain access to those premises, and the tenant has to pay for you to get that court order. Pretty simple and pretty powerful. We've done that quite a few times in the recent past with folks who were not tenants who weren't giving access to the landlord, and they were basically causing problems. They were delaying construction, they were delaying inspections, and they were basically just playing games. And so we've been able to use this statute to gain access to the premises. Now there's a flip side. There's two sides to every coin. If you are making repeated demands, and although they're lawful demands, but you're effectively harassing the tenant, then the tenant actually has a right to go to the courthouse and prevent you from continuing to harass them if they can prove that claim. So what does that really mean? It's pretty straightforward. If you've given notice and the tenant isn't giving you access, then you have a right to use these statutes. Get the judge, get the court involved, make sure you've got a right to gain access, and in certain circumstances, if the tenant continues to refuse to give you access, you can actually have the tenant removed and not even have to go through the eviction process. That's the termination of the rental agreement. So it is a powerful statute. It is the answer to the question, can I gain access to the unit? The answer is absolutely yes. If they won't give it to you once you've given notice, if the tenant won't give it to you once you've given notice, then simply use the courts and you will absolutely gain access to the units. Hope that was helpful. Again, Robert Chesson with the Landlord Law Firm. We'll see you back here in August with another edition of the LLF TV Live Landlord Advocate. Take care.